One, could I have parties announced?
Andrew Harris Edelman for the state.
And this is Pauline Portillo along with Ms. Peyton Howe for Mr. Felipe Serna Reyes.
All right, you all are scheduled for jury trial today. You filed a motion for continuance?
I did, Your Honor.
All right, and why?
We have several reasons. We do have a motion to inspect and examine evidence, which if granted, I think will...
The courtroom drama kicks off before the judge even settles in. Chaos is in full swing. The defense stumbles in late, disorganized, and scrambling like unprepared students on test day. Meanwhile, the judge enters cool but visibly annoyed, clearly not in the mood for nonsense. And just when things should be getting serious, it's jury trial day. After all, the defense drops a bomb, they want a continuance. What follows is pure procedural mayhem, with rising tension, legal panic, and a meltdown that turns this into one of the most chaotic trial days you'll ever witness.
Require us some time to inspect and examine that visible evidence.
Why wasn't that done before today?
Because, Your Honor, through preparation with my client, which was very limited because of the time frame which we represented him, this was information I had to develop over the course of jail visits, which I couldn't get within 24 hours. And so through prepping with my client, we learned of some evidence that might be, and I would expect strongly, would be material and mitigating to the elements in the case. And so that's the reason why it wasn't filed earlier on in our representation of him, but it was filed before the jury trial date of
27.
the 27th, yes.
All right, anything else with regards to your motion?
I'm sorry, it was filed May 23rd, 2025, and I'll address that motion in a second. But the other issue is, Judge, we had requested missing discovery from the state, and since that request, we've gotten in about 12 videos that are pretty large, and even the state said it's a pretty big file that it took.
What missing discovery?
At this point, it's all been produced, but they are all recordings from SAPD personnel who are at the scene.
Okay.
And they're pretty large videos, Your Honor. And one of them, I think, includes the unmuted portion of the defendant's statements. And I also believe that that's going to have material and mitigating evidence for his defense. So it's really, really crucial for us to be able to review all.
All right, so review the video now.
Judge, these videos are an hour and a half.
Review the videos now.
The defense dives straight into excuse mode, offering a rambling explanation for why they're completely unprepared. Their main excuse? They just realized they need to review key physical evidence on the very day of the jury trial. Seriously? They knew the date, they knew the gravity, yet somehow never got around to this basic prep? To make things worse, they toss in jail visit restrictions like that's supposed to wipe the slate clean. The judge isn't buying it. Her tone goes cold, cutting through the nonsense with a single pointed question: why wasn't this done before today? No patience, no pity, just sheer disbelief. This isn't a pop quiz, it's a felony trial. You either come ready, or you get scorched.
And then the other issue with the motion for continuance is the other issue with the motion for continuance, Judge, is that to prepare an adequate defense for him and to avoid issues of this case being appealed for ineffective assistance of counsel.
People love to throw around ineffective assistance of counsel. This case has previously been set. He had another attorney. It was set for jury trial, and your firm decided that you were going to represent him and get on a case knowing that it was set for trial. So if you all want to throw your swords on ineffective assistance of counsel and file that with the appellate court, that's completely up to you. Next one.
Your Honor. The issue is that it is very apparent to me that because there was so much missing discovery that was never requested, that there was not adequate prep work by the prior attorney. And that's why, unfortunately, and I don't want it to be held against him, it's taking us so long to put everything together and figure out the missing pieces.
Oh, no. Name the parties who you're saying didn't complete adequate discovery.
Name the parties that
Oh, yeah. Who are you talking about?
The state.
Okay.
So the issue, Judge, is that I don't think that this should be held against him. He's facing substantial jail time. It's an enhanced first degree possession.
Just when it seems the defense can't get any more chaotic, they reach for the Hail Mary, claiming ineffective assistance of counsel. Seriously? That's their move now? The judge doesn't even flinch. In fact, she nearly laughs them out of the room. With razor-sharp precision, she shuts it down. You chose to represent him, knowing the trial date. This isn't some mock courtroom, it's a felony case with real consequences. Yet here they are, tossing around legal buzzwords like it's a Twitter thread. The judge has had enough. Her voice turns cold as steel. If you want to file that with the appellate court, go right ahead. Translation? Your excuses are now officially irrelevant. The courtroom just got ice cold.
They require a lot of links, a lot of connecting the dots. And so my argument for the continuance would be that we definitely need some more time. Just
All right, the
because of the
video
nature-
is like an hour. What did you say, an hour and what?
So the 12 videos, each one starting at least at about an hour and a half long.
All right, so y'all need to watch the videos today. He's here, you're here, watch the videos. Next point.
We'll do, Your Honor. But the other point is that this is a case that has a lot to it. And so it's not just a regular, like a DWI third or another felony that you could get ready for very quickly. And so given the nature of this case and the prep work for it, that is a little bit above and beyond another felony in this court, that's also the reason for the continuance.
All right, but you all knew that this was set for jury trial. And so you all chose to do it. You've been given your 10 days. So what's your other grounds for a motion for continuance?
That I don't have any other grounds coming on, Your Honor.
All right, so you all need to look at the whatever video she says he needs to see. If you will load it up so she can watch the video with her client.
And Judge, I tried to do that when I was here about a week and a half ago, and the state never was able to give me the video because they were too busy. And so
Well, do you see anyone else here now? Load up the video so she can watch it with her client.
Don't you have access to it now?
we requested, but it doesn't come over right away.
So you
It
don't
takes-
have it?
No.
Okay.
So the other issue, Judge, is we have a motion to inspect and examine physical evidence. The state tells me that they're not opposed to it.
Well, you all should have done that before your 10 days. You had plenty of time to inspect evidence. So,
Okay, is the court going to rule on it?
oh yeah, you can expect whatever evidence you want to inspect, but I am not granting a motion for continuance because you all have not inspected evidence that was always available.
Now the defense pivots to their next excuse, the video files. They claim they just got 12 hefty SAPD recordings, each around 90 minutes, and insist they must review them before trial can proceed. But the judge isn't having it. With surgical precision, she slices through the noise, then review the videos. Boom. No delay, no sympathy, just cold logic. The tension in the room spikes. The defense tries to shift blame, hinting the state dragged its feet, but the judge doesn't flinch. She's done playing the villain in their narrative. She reminds them, again, they had the time. This isn't just a ruling, it's a power move. She's reclaiming control, and every passing second is a noose tightening around a defense buried by their own procrastination.
Would you like a copy?
They've given me copies of your motion. So state, she wants to inspect evidence. Is there any other motion?
Judge, it's just there's two motions for each cause number.
Okay.
So I just wanted to see if we could get your signature on both cause numbers.
Okay. And other than that, is there any other motion?
Yes, we have a motion to require disclosure of all informers relied upon and for production of said informers.
All right. So what are you basing that? And you're speaking of a confidential informant?
I believe it is, Your Honor.
So there are certain grounds legally where you're allowed to that information. So what are you basing that request
So
on?
Judge, there's a reference to an anonymous tip by the detective in this report. And so I don't know, I think we need to call him in to at least get some testimony about what the anonymous tip was. And generally speaking, like what's the nature of it? What did it reveal? And if it's somebody that this person has worked with in the past, because that's all I have is that it's an anonymous tip. There's no other
Stay.
information included there.
I can call Ramirez, see if we can get him here.
Okay.
and scrambles again, this time waving around a motion to inspect evidence they've already had access to for 10 days. 10 whole days. The judge doesn't even blink. Her patience is on life support. You had plenty of time to inspect it. Boom. Motion denied. No emotion, no argument, just cold, courtroom facts. Then, in a last-ditch grasp, they bring up an anonymous tip and demand the identity of a confidential informant. But here's the kicker, they can't even support it with proper legal grounds. The judge hears them out with a face that says, "Really?" then moves on without hesitation. Because this isn't some crime thriller, it's a court of law. If your argument's flimsier than your prep, you're not getting traction. And right now, they're sinking fast in a pit of their.
And then we just have other pretrial motions that I expect we could argue.
Did you all confer with the state on your pretrial motions?
I haven't. Does the court want to take them up at this time?
Well, I mean, don't you want to confer with the state to see if they're in agreement with your motions? If you don't want to do that, I will hear them. But it would seem it would be economical to see whether or not the state agrees with your motion, then maybe you wouldn't need to have a hearing on it.
Yes, sir.
All right, while y'all are going over these motions, you need to start watching a video with him, and I'll take your motions up after you finish watching a video.
The prosecutor doesn't agree with the two motions.
All right, so go ahead and watch the video.
This hearing wasn't just a mess, it was a revelation. What unfolded in that courtroom wasn't mere disorganization, it was a masterclass in how easily justice can be jeopardized by incompetence and delay. The defendant is staring down enhanced first-degree felony charges, his future literally on the line, and yet his legal team showed up with missing discovery, last-minute motions, and excuses piled up like a losing hand at a bad poker game. The judge didn't blink. She saw it all, understood the stakes, and made it clear, this trial isn't going to pause while people learn how to do their jobs. Court isn't a warm-up act, it's the final performance. And today, the defense came unprepared for the spotlight.
Motions will only take 5 minutes, maybe.
Okay.
All right, thank you.
I'm sorry. Am I showing him the video on the prosecutor's laptop or?
However you all do it.
Okay, that's the only way to do it because we don't have the video.
All right, so this is the thing. If y'all want me, I will step from the bench. I will load up the video so that you can watch it. I don't see that as my job. So you all need to talk to each other. I don't know why it's so hard to talk to each other and get things done. You say you want to see a video, then you're going to watch the video, but this case is going to trial today. We're doing jury selection, and that jury selection, I'm giving y'all this morning to do your videos. That jury selection is happening this afternoon. So either y'all want to get together and look at the videos or you don't, but at 1:30, we're doing jury selection.
And here it comes, the final blow. The judge, clearly at her limit, gives the defense one last chance to load the video files, practically holding their hand through basic courtroom procedure. It's beyond frustrating. Then she drops the hammer. This case is going to trial today. No more excuses. No more delays. This isn't a rehearsal, it's the real deal, and the clock has run out. The message is loud and clear, show up ready, or don't show up at all. And if this is the level of sloppiness we're seeing in open court, just imagine what's happening in courtrooms without cameras. If you're shaking your head in disbelief, you're not alone.